I'm Guillermo Hernandez, an immigration attorney here in San Antonio, Texas. I'm here with my colleague Roberto Campos, and we're doing our Facebook Live session in English today. So we'll be live for about 30 minutes or so. If you about anything regarding immigration updates, things that are happening, we encourage you to make a comment, and we'll try and to get to any questions we have. También hablamos español en caso que quieres hacer una pregunta en español. We have our offices here in San Antonio. We also have offices in Edinburgh in the Valley. And we take immigration cases that are family petitions. We take citizenship cases, handle in cases that are in deportation, in immigration court, deportation defense. And we do some also employment-based and investor visas. And so we'd be glad to also consult with you in those cases in case you have those. So today we're just going to give some general updates about what's going on now that it seems like more people have gotten the vaccine. The number of cases with COVID and the pandemic are lower now. So we're starting to see things open back up, and that's including the immigration courts. So we got a notice this past week on Monday that the immigration courts here in San Antonio, it sounds like most immigration courts nationwide will be reopening on July 6th. And I did notice that it included Houston and Dallas and some of the other courts here in Texas. And so I think that's important news to share because a lot of people might have a case in immigration court that it's kind of been in limbo for the past year since last March, where they either had a final hearing scheduled or a preliminary hearing scheduled, and all of those cases have been moved out and have been pushed and rescheduled because the courts have remained closed. So finally, we'll see that the courts are going to start to reopen. So that, like I said, that includes the San Antonio immigration courts. And so to that end, it's important for people who have a case pending with the immigration court to make sure you check your date, right? There's a phone number you can call to see when your hearing is scheduled for, if it's been changed. There's a website on the immigration court's website that you can type in your A number, your case number, and see if your court date has changed or if it's, what date is scheduled for. So I think that's important. I think it's, if it's coming up, to talk to an immigration attorney, somebody that can advise you what options do you have, what kind of case can present in an immigration court. And we've seen, we do know open, the courts are going to reopen at a reduced capacity, which means they're not going to have all 8 courtrooms open with forms. Or can you tell us a little bit with your experience? What was it like before COVID? What was it like to go to court?
Well, it was pretty crazy there. Well, the court that corresponds to us, or the court where we spend most of the time, was the one in 800 Dolorosa Street in San Antonio. And it was, first of all, it was pretty packed. It was full of people. Every single room was full of people, including respondents, including attorneys, including the judge, translators, who else? The assistant to the judge, the bailiff was there sometimes. So it was a pretty packed court. I would say maybe between 30 or 50 people sometimes. So I think that's going to change for sure. Hopefully we'll see a more organized system whenever we get back. I know Guillermo was in a meeting a few days ago with the judge who will be supervising the San Antonio immigration courts, and I think they're going to implement a few changes that are going to be good for respondents and even for attorneys as far as time efficiency goes. I think we're going to see more interaction with the court on paper instead of going to the court every single time. And unless we need to fight something in court, that's when we will need to go and actually appear in person. Am I correct?
Yeah, so just I remember times pre-COVID where there was lines of people on the bottom floor waiting to get up the elevator. There was a line, down the long hallway of the immigration court, and they would try and limit people in the courtroom, and allow represented individuals to go first. So it was a very kind of crazy, chaotic system. So what we've been told is that these kind of preliminary master hearings that would occur normally are not going to happen as they have before. At least kind of in this first phase of reopening, the courts are just going to be hearing individual cases. So it's going to be like an individual hearing, a final hearing for people that have already had these scheduled. And they can proceed to present their case and have a final decision of the judge. And the reason for that is it requires less people to go to the court.
Yeah.
And they're going to be doing that on kind of on a reduced capacity, and that not all judges will be there. It'll just be about 4 judges when they first start opening up, hearing these individual hearings. And so it's good to know because they're taking the COVID precautions seriously about social distancing, making sure everybody is safe and feels safe. So even if you have a hearing coming up, it may or may not go depending on what phase the court is at in reopening, because we do know they're going to kind of reopen at a reduced capacity. And I do think it's important too that it will look different in the sense that we're, the court's going to issue scheduling orders and dates that you have to have certain documents in by or applications for relief to cut down on the amount of time that somebody may have, and to kind of limit those court hearings to things that you need to get resolved in front of the judge that may be more contentious or need to have argument in front of the judge. So it'll look different for sure. But the good thing is that we will get to see some movement on the cases and so I do think it's important people know, right, that the courts are reopening and know to check their cases. Check the dates, and if you have something coming up, make sure you talk to somebody that can help guide you through. So I think we were going to talk a little bit about today, with the news that the courts are reopening, what does it look like? I think we can talk about, what do they look like before, but also what is it going to look like moving forward? Is there a claim for relief? What even starts the process? And even that may be changing because of, we have the notice to appear that normally starts the process, but there's even, we talked a few weeks about case law that's come out that could affect that. So what can somebody expect, if they've been put into immigration proceedings, what's the first thing that happens?
Okay, so as far as how the process is going to work whenever you go back to your first court, and usually before, like pre-COVID times, you would need to go to the court the first time, and then the judge was going to read your rights and give you an opportunity to find an attorney if that was your. And then if you ended up hiring an attorney, depending on the type of case you have, you could either file, or I think our main 2 forms of deeper defense are either cancellation of removal or an application for asylum, which is a 589. That includes the application for asylum and withholding of removal, right? So we have those 2 options mainly. There are a good number of things that you can do in front of the judge when you are in removal proceedings. But basically, for the purposes of this video, we're going to discuss asylum and cancellation of removal, or what some people know as ley de los 10 años, right? So,
so I think it's important to talk about this. And I think even before you get there, right, before you file relief, your issue was called a notice to appear. You want to make sure you go with an attorney and make sure everything on that is correct.
Yeah.
That's an important document. It's the document that starts these immigration proceedings. And if something's wrong, your name's wrong, if there's, even, the most recent fight has been whether it has the date or time, you know, you want to make sure that you go through all the allegations that are on there and the charge carefully to make sure it actually applies. Because sometimes there can be a basis to fight just a notice to appear and say, this doesn't apply, my proceedings should be terminated. And that may be one way to close the case, right? And so looking at that, and then you have to make pleadings. The judge has to find somebody that, that they are subject to being removed from the United States. And then you look at what kind of relief is available. I know today we're going to talk kind of briefly about asylum, withholding removal, protection against torture, and cancellation. But even those, those are probably the more common cases we see. But there's also cases where somebody was a permanent resident and is put into proceedings either because of a criminal conviction or something that has jeopardized their residency. There's people or who may have to seek a waiver for fraud in proceedings or misrepresentation. There's people who have VAWA that can seek like VAWA cancellation. And there are also sometimes like kind of ancillary relief that is being sought outside of court. Like if somebody has an approved I-1, they'll be able to adjust in front of the court and do an adjustment of status. Or they might have a TV source, SIJ, Special Immigrant Juvenile. So while we're talking about kind of the two main ones that we see often, I think too it's important to talk to an attorney to evaluate completely your claim, because there could always be something else that you may not be aware of that could be available to avoid a deportation order.
Of course.
So, Roberto, tell us a little bit briefly about asylum. What do I have to show? What kind of, first of all, what do I fill out? What is that?
Of course. So as Guillermo was explaining before, once you've complied with those elements of the ENTA and reviewing the ENTA and make sure that everything is right, you can move forward with the filing of the I-589. So the I-589 is the actual application, the form that you need to fill out and file with the immigration court. This is like an 8 to 12 page document, depending on how extensive is your case. You can always include more pages if the substance of your claim, if you don't have enough space to actually explain the substance of your case. And in that form, you will be able to briefly explain the reasons why you came to the United States. So asylum is a form of relief that protects people that are fleeing their home countries because they've been either persecuted, abused, harassed, or any of those type of actions because of 5 different they need to be under 5 protected grounds, right? Which is because of your race, religion, nationality, political opinion, or membership in a particular social group. So we can do like a full live talking about these 5 protected grounds, but we need to prove to the court that this person has suffered persecution either in the past, and that was the reason why they came to the United States, in the future, in case anything has changed in their home countries. And there are a couple of things that we need to talk about regarding matter of ACAA, that decision that was trying to be implemented last year under Attorney General Barr, that will change, is trying to change certain elements of these type of claims. And the third element, which is like really important, is the acquiescence of the government, right? And that means that, for example, a person in El Salvador tried to go to the police and make a report about some stuff that he was going on that was life-threatening. And the police decided to do nothing. And he has several police reports to prove that he actually went to the police and wasn't able to get a good response from them. And that is one of the ways to prove acquiescence of the government. So I think that's a general idea of the elements that are important in an asylum application, right?
Yeah, I think so. And I think, again, it's important to go through these cases like in an evaluation with an attorney who can see, okay, we do have an argument here for religions because you were attending church and these people, took action against that church or that specific belief, or belong to a certain indigenous tribe that you're suffering persecution, or it's because of your political involvement. Some of the successful asylum cases we've had, out of Cuba, out of Venezuela, it's because people were politically involved against the government, and we were able to show, that the reason they were detained and abused and harassed was because of their political beliefs. And even more complicated is a particular social group, right? If we can't make it fit into political opinion or race or religion or nationality, then we have to look and see, is there something distinct about that person's case that makes them a target for persecution? Something distinct, like within the community they live in. And so they can be some pretty involved and complicated cases. So I think it's important, I know that the Attorney General has come out with like decisions, prior to sessions with several different, opinions with matter of AB, matter of LEA, kind of have changed or rephrased what essentially make it harder to seek asylum based on this overturning precedent. But that doesn't necessarily I think that doesn't necessarily change the way you prepare an asylum application, right? Because if you can meet the burden and show that either this person suffered past persecution on account of this protected ground, or they have a well-founded fear that there's at least 10% chance that they're going to suffer persecution, physical harm if they return to their home country, that they should be granted asylum, of course. And so I think it's important to look at all of that kind of stuff and make sure that you include evidence of what maybe they've suffered before, include evidence of the country conditions, expert reports, police reports if they're there, medical records, and try and really support the testimony of somebody that's going to present their claim for asylum.
Of course.
Because I do think, precedent-wise, it's gotten more difficult, but, these cases need to be prepared just so that the respondent can establish the burden that they qualify for this. So they can be complicated cases, they can be tough cases, and I honestly think like in the past, you lose more, you win, but it's something that good relief for people, that you really have a fear of returning to their own country.
Of course.
Yeah. So tell me about La Ley de los 10 años.
Okay. La ley de los 10 años, and this is a really important topic right now, especially with the new decision that came out a few weeks ago, and I'm gonna explain why, and then Guillermo, if there is something that you want to add, please feel free. So basically, what the ley de los 10 años or cancellation means, this is also called a 42B, and this is for people who are undocumented, basically in the United States. They have been in the United States continuously for 10 years prior to the filing of the NTA, and this is where the tricky part comes, and I'll go back to that part once I'm done with this portion. So the first requirement is 10 years of continuous physical presence in the United States. So that means if you came to the US and then you left because you were attending a quinceañera and then you came back, that cuts it all.
And it depends, because there is some case law that would allow for brief, casual, innocent absences. But if you have more than 90 days outside the United States, that is considered to interrupt continuous physical presence. Or if you're apprehended and you sign a voluntary departure and knowingly waive rights of cancellation, there are other things that can affect that continuous physical presence. And I think one thing that's important about, we're talking about La Ley de los 10 años, this is one requirement. We get clients that come in and say, ya tengo mis 10 años aquí, puedo arreglar this. I've been here 10 years. Is there something I can do now that I have my 10 years? And it's not that simple. There is no just automatic, I've been here 10 years, I can adjust. As you were saying, it's one of the requirements. Yeah. So what else do they have to show?
Second one is good moral character. So, and this is like a super wide requirement because it implicates a lot of concepts, a lot of definitions, a lot of different moving pieces that can actually affect the case. So, for instance, if one of the things that could have moral character is criminal history, right? And of course, depending of the type of criminal violation that you probably had in the past, you can actually determine if you can qualify for this form of relief. That's the second requirement. The third requirement, and this is probably one of the most difficult ones with the cancellation of removal, is having a qualifying relative. And a qualifying relative could be a spouse, minor kids, or parents who are either U.S. citizens or legal permanent residents of the United States. Um, a few cases that I've been one of the first cases that I tried with Guillermo, well not tried, that I saw with Guillermo was included a family that had kids who were DACA. So the problem with DACA is that it's not a legal status per se. So that cannot qualify as a qualifying relative for the purposes of cancellation of removal. So we need to be very careful with this form of relief, and especially screening on who's a qualifying relative. The other part of a relative that is really important is that this person will suffer extreme hardship. And Guillermo, can you explain us a little bit more about what does extreme hardship mean?
Yeah, and I think so. And it's going to be like parsing the words, but it's exceptional and extremely unusual hardship. So, extreme hardship, and this is again like the legal jargon, but like extreme hardship is considered like one level, right? And we have to show extreme hardship, for instance, in a waiver application. Exceptional and extremely unusual is a higher standard, right? Like, so it's higher that we have to show that the qualifying relatives would suffer this hardship level. And I think it's important to qualifying relatives, the children have to be under 21. And so that's an important thing to watch out for, because you could have a child that could be potentially aging out. And we have seen that in some cases where we need to push the cases forward quicker because, they might only have one qualifying relative that's a U.S. citizen child that's 19 years old, and it can take sometimes over a year to get an actual final hearing. So that we're dealing with that in one of the cases now, and thankfully the courts have reopened, and we're going to try and push for an expedited hearing on that case. But for hardship, you really have to start showing that's exceptional and extremely unusual, and what that means is something different than like the normal average family that's going to go through a deportation experience, right? So for whatever that means, right? Because I think anytime you separate a family, that's extreme and unusual. But obviously the judge is going to want to see evidence of that. So the court can consider anything and everything. And so to make these cases, we look at economic hardship. What is that going to look like for the family members that are being left behind? The judge is going to concentrate on the qualifying relatives. So either the children, the spouse, or the parents that that will suffer. So are there medical issues? Are there psychological issues? Are we looking at depression? Some of the cases that we've been successful, we've had a good psychological evaluation showing that the minor children had suicidal thoughts and were dealing with depression, and because of that psychological hardship, we were able to meet the standard. Or it's been because of medical issues, right? One where one of the children had autism, and actually did a great job testifying in court. And I think that's why the judge granted, because they could see the necessity of the relationship of the father that was in removal proceedings. And so it has to be something that a judge will recognize that this is not the normal case. This is something that is exceptional. This is something that's unusual. And to be honest, I think you can get there, with enough evidence if you can show psychological, you can show economic, you can show change of standard of living, what are the country conditions at, and would the children go, to wherever the parent is being deported to? How old are the children? Do they know the language of the country? There are so many things that you can consider and use to bolster the hardship level to try and get you to where you need to be. And so, I mean, that's an important thing, because without, you could have somebody who has no criminal history and good moral character, somebody who clearly has the 10 years, and who has the qualifying relatives, but if you don't show that hardship, then you don't get the grant. And I think a lot of times that's what these cases come down to. I've been in enough of these cases where we'll talk to the DHS attorney beforehand, and they're willing to stipulate, okay, there's no criminal history, we'll stipulate good moral character. There's no gaps in presence, we show tax return bills, there's enough evidence to show that 10 years, then they'll stipulate to that. We obviously can show the qualifying relative because there's a birth certificate or marriage certificate, so they'll stipulate to that, but I don't think I've ever had a case where they stipulate to hardship, okay? One was close, it was more of a, okay, is this one extreme and hard, unusual? I remember the TA asked, like, is this normally a stronger case than you would normally say? And I said, yeah, of course. Like, and of course I'm going to say, yes, this case should be, like, you should agree. But he said, okay, well, I'm going to let you present the case, and I'm going to defer to the court. And that's as far as we got. It wasn't a stipulation, and there was some questions about everything. But I don't think I've ever had a trial attorney come out and say, we'll stipulate to everything and give you the grant. Maybe that'll change now that there's going to be some hopefully new priority and prosecutorial discretion coming out that we're waiting on President Biden. But hopefully we'll see some changes in that as well from the trial attorney.
And I think about going to the court is that I think that people sometimes feel that it's you, the attorney, the applicant, and the judge. But you just mentioned the presence of the trial attorney, and it's really important to note that the trial attorney is the government's prosecutor. Mm-hmm. So if the applicant is not complying with whatever requirement the government is imposing, then we can get in trouble. If the applicant decided to not show up to court, then we can get in trouble. So that's why it's very important to keep in touch with your attorney and make sure you go to every single of your hearings.
Yeah, and comply with, right, because there's like biometrics requirements. You have to go get your fingerprints taken. And ultimately, if you don't comply with these things, then the judge can just order the removal, and unfortunately, that's how the case ends. So, yeah, I think that's a very important point.
I think we are. That's like the general perspective of cancellation and asylum. We have like 1 or 2 minutes left.
Do we have a question?
They're saying like best immigration lawyers.
Oh, thank you.
So I think I would like to talk about the work permits regarding.
Oh yeah, I think that's a good point.
Can you tell us how can you apply for the 765 or for the work permit?
Yeah, sure. So I think for each one it's different, and you have to show different things. Cancellation of removal, once you file the application and have it, say like staff the immigration court, and also you have to show. Normally the court won't accept it unless you feed it in as well, or that you paid the fee. There's a $185 fee. It's been a while now since I've been in court, so you have all that memorized. That you paid into USCIS. So once you have the receipt, the stamp of the court, you can apply for work authorization, and normally those are taking about 5-6 months, I would say, and they're valid for a year. So you have to renew every year, but it is, it'll allow you to work with authorization, get a social security number, apply for a driver's license while you're waiting for your application to be adjudicated, that final hearing. And so it's a good benefit, right? Because it allows people to kind of have some stability while they're waiting for a final hearing on their application. With asylum, it's a little bit different. So the law or the regulations now after August 25th of last year are that you had to have not entered iwi, or you have to be able to justify the iwi entry, have to have put in your application within 1 year of your entry, and you have to wait 365 days, 1 year from the date you filed your application for. So these are extra requirements that exist before. So generally, that's when you can apply 1 year after the application is pending. Now there is pending litigation, and there are memberships. There are two cases, CASA and ASAP, that clients can apply for membership to, and if they qualify and are approved, then they fall back under the old regulations that allow you to apply for work authorization after case. You can submit the application at 150 days. And it can be approved after the 180 days. And the other requirements about the iwi or the entry without inspection or the deadline are taken into consideration. So the difference under the new regulations and the $85 biometrics fee for the first employment authorization document, that does not exist under the ASAP or CASA class members. And so it's a good benefit. Generally we've been encouraging our clients to register as members so that they can take advantage of the benefits that come, especially when it comes to work authorization. Oh, and the other big thing is they have to be adjudicated. They should be within 30 days of filing the application. And that's not the case under the new regulations. So it's two different processes depending on what application you file. But with both applications, you can at some point file for work authorization.
So I think that's everything we had on the schedule. We're over the 30-minute mark.
Yeah. Well, like I said, we're immigration attorneys here in San Antonio. If you have a case, we do speak Spanish as well. This is our English program. Next Thursday, we'll be doing Spanish live at 6 p.m. in the evening, and we'll be glad to take your questions at that time. And in the meantime, if you have any questions about your case or want to schedule a consultation, the initial consultation is free, and we'd be glad